the petitioners. Shadan sir, what exactly was this? Justice Dhulia has raised certain issues regarding right to freedom of expression, freedom of religion and the right of choice and the importance of protecting the women's rights to education. But what does this verdict really mean now? Will this go to a three-judge bench or will it go to the Sabrimala bench?
No, so there is a disagreement between two judges and on a fundamental aspect of constitutional protection of a headscarf. And it will go to most likely three judges, because when there is a disagreement between two and they have said it has to be placed before the Chief Justice, there is no reason for this matter. Unless there is something in the orders, we are yet to see the orders. Unless there is something in the order which indicates that a larger bench is required. But at least what was read out, there was nothing of that sort. So it should go to three judges. And of course, Justice Dhulia's judgment is very specific in terms of that his main consideration. He didn't read out the operative part, but he read out what was the final outcome and what was playing in his mind in terms of why he gave the judgment.
Justice Gupta, however, has framed 11 questions of law, including whether ERP issue has to be gone into, whether there is an inherent right to wear a hijab, whether there is a right as far as the wearing hijab in school is concerned. And I'll take this question to you, Mr. Pasha, because one of your arguments, a very passionate argument during the hearing, was that hijab is an essential practice, that you cannot say that this is not an essential practice. So what happens now?
In fact, my argument was that you cannot go into the question of essentiality. Even if you go into the question of essentiality, this is essential. And Justice Dhulia has held that there was no need for the High Court to go into the question of essentiality. This is a question of freedom of expression, freedom of conscience, and the right to education. This is not about essentiality. And it's on these lines that Justice Dhulia has decided the matter has to go to a larger bench. The strength of the bench, they have just said that it will be placed before the Chief Justice for constitution of an appropriate bench. That appropriate bench may be 3 or 5, depending on what view the Chief Justice takes in an administrative capacity, based on the questions that arise in the appeal. So that is something we will have to wait to find out for that bench to be constituted.
Sir, he has also mentioned the Bijoy Emmanuel case and that this matter is squarely covered under that. What does that exactly mean for the argument or the way this issue has been addressed?
See, just like in Bijoy Emmanuel, there were kids who were standing in respect for the national anthem, but because their religion did not allow them to sing, because they believed in humanity of the entire, entire globe, they didn't believe in nationalism. Therefore, they were not allowed to, by their religion, to,
So in that matter, the court had said that you can choose not to sing the national anthem.
Although you are not disrespecting the point of national anthem. Similarly, these girls, they are just wearing a headscarf. They are not in disrespect of the uniform. They are wearing the rest of it is uniform, right? Just like we see lawyers, women lawyers who wear the dress I am wearing, right? A coat gown and everything, and just wear a headscarf. So how is that a disrespect? So same principle applies even to a school. And I think that's the, so there was a completely direct analogy, and in my view, I think the Justice Dhulia has very directly and correctly applied that here.
And we had in fact argued that the case is squarely covered by Bijoy Emmanuel. That was the argument. That was the argument on our side. Yes.
Sir, now what does this really mean for the girls in Karnataka? Because now this matter goes to a larger bench. It is going to be, which is going to first consider all of these 11 questions that Justice Gupta has framed, and Justice Dhulia has presumably agreed with these questions at least. So what does this mean for these girls in Karnataka? Legally, what is currently the status of this hijab?
So, see, the judgment, one judge has set aside the judgment, one judge has upheld the judgment. You would have needed a quorum of 2 to set aside the judgment. So technically, in my view, I don't think the judgment of the High Court today stands set aside. So to that extent, the status quo may continue. We'll need to have, again, a closer look at the judgments in terms of if they have made any observations in terms of how the judgment will operate of the High Court. But just prima facie, that's the sense I get. And therefore, the new bench which will be constituted, that will have a relook. So my sense is, for the moment, it will probably be status quo of what was already existing.
So, which basically means that at the moment, since the hijab is not allowed inside the schools, that status is likely to continue till the larger bench takes over.
That is correct.
So what does that mean now for this?
Only one thing I'll add, that the judgment related to only PUC, right? If you look at the operation on the ground, that is class 11th and 12th girls. Now, it has thereafter been expanded to other areas as well, right? By certain orders, or even informally it has been done. Now, to that extent, I don't think even the High Court judgment protects those kind of restrictions. Because what was upheld was only 11.
In the PU colleges.
Correct. So that's right. Only to that extent, the
government PU colleges. Government PU colleges.
So at the moment, only in the government PU colleges where uniforms are specifically prescribed, this kind of ban is likely to continue. But what about the other schools?
See, because now the matter itself is sub judice, and there is no interim order. Either the Chief Justice may pass some interim orders, or may constitute a bench that will pass an interim order, or we may approach the Chief Justice for constitution of a bench for an interim order. But until an interim order is passed, then status quo will continue, and that status quo is that only insofar as the government PU colleges are concerned that prescribe the uniform, there is a restriction. The judgment had gone far beyond even the government order in saying that it is not an essential practice, and even in other institutions, etc., it was being disallowed. So all of that now will have to go, because the judgment in that sense today is not good. It's not.
It is not good law.
It's not good. It's not. Or it may not. Yeah. It's not technically being set aside, but there is a judgment of the Supreme Court of one judge which says that it's bad law. So in that sense, I think the status quo continues.
In a grey area, and the status quo is likely to continue till a larger bench takes this over. Thank you very much, Mr. Farasad and Mr. Pasha, for speaking to India Today.